Good morning, everybody, and welcome to the Legal Expertise D&O Claims webinar with special guest attorney Mark Markel. I'm your host, Sherry Branson. Today, Kevin and Mark will discuss D&O claims affecting community associations. Both Kevin and Mark have worked in the community association industry for many years and will share their expertise with you today. Thank you for joining us, everybody. Please review their bios, which are coming up on your screen in a minute. I just wanted to mention that I record all of our webinars and I put them on our website, which is kdisonline.com. You can listen to today's webinar and all of our past webinars by visiting our website. If you have any questions for Mark or Kevin today, please type them into the question box, which is on your screen. You see the toolbar, you'll see polls and then questions. Please type them there, and then we will be answering your questions at the end of today's webinar. I'm now joined by Kevin Davis and Mark Markel. Good morning, Kevin and Mark. And Kevin joins me from Los Angeles. Hey, Kevin.
Hi, how you doing?
Doing well, thank you. Kevin, we have a little bit of weather happening today. Mark and I were talking about it earlier. I have some thunder and lightning, so it's not sound effects, it's actually weather in the background. And if you happen to lose us, don't worry, we'll try to come back on. But
okay, I think you can handle some of this stuff too without you, Mark. So I think it'll be okay. How you doing today, Mark?
I'm doing fantastic. I'm trying to stay dry here and keep my power on.
Wow.
Me too. Well, take it away, you guys. Have fun. Have a great webinar.
Okay, all right. Thanks a lot, Sherry. We'll see you in a little bit. Okay. All right, Mark, so we got some interesting stuff to talk about today, don't we?
Always. It's always something new too, Kevin.
Yeah, you know what? It's stopping my lunchtime though, so I'll probably stop your lunchtime also, right?
Well, it's 1 o'clock Central now, so
Okay.
it's just cutting into my union break time, but I'm welcome to talk to y'all.
All right, so we'll talk today about D&O and claims and what's going on out there. So I guess kind of jump into it at first. We'll talk about the coverage.
All right.
We talk about D&O insurance, Mark, we're talking about there got to be three things that really that matters. Okay, when we talk about D&O insurance, we're talking about who's an insured, okay, wrongful act, and what is a claim. So let's start with who's insured. Under most D&O policies, we know it covers past, present board members. We know it covers committee members. We know it covers volunteers. And we know it covers the association itself. But you see things differently in some of the D&Os you've seen, right?
Right. Now, what you've just described are some of the better D&O products that are out there. And there's a handful that cover what you've discussed, but they're not the only ones that show up. And unfortunately, I've come across some really, really ugly D&O policies. And the one thing that we always advise is to read the policy, which is really kind of hard to do sometimes. So if you can't read all the little print, at least read some parts of the little print. And the first thing I always have them read is who is it insured. We came across a policy not too long ago, which covered existing board members and the association, but the association had a massive deductible and there was no deductible at all if an individual director was sued. But it didn't include past and it didn't include committee and volunteer people, only named board members. So it was what I would call a pretty horrible policy. It was also an expensive policy and I didn't know why it was so expensive. But after we were asked to review it, they canceled that one and obtained a better policy. And there's a ton of them out there, especially on the insured issue. The developer control boards really need to pay attention because oftentimes they get tossed off after the first election after turnover.
Mm-hmm. Yeah, and one thing too about the insured also is that sometimes you have that only does not even include the insured organization. So if the insured organization is named in a lawsuit, they exclude also. Have you seen that?
Yes, I have, and candidly, I think you guys bring this on us because you call it D&O insurance,
Mm-hmm.
which is directors and officers insurance.
Mm-hmm.
I'd rather say property owner association insurance so where we could have a description which may be a little bit more broad on top of it. But since the beginning of time, we've called it D&O, and that's what it probably will stay at. But we just need to make sure that people are knowledgeable enough to look beyond the D and the O.
And that's a good point, because historically it was called D&O insurance because directors and officers were the ones that made decisions, and they're the ones that were covered. So now we go to these nonprofit area days where you have committee members and board members and past board members, and you have these volunteers who are involved in the association. And you can actually sue the architectural review committee because they approved somebody's house, they shouldn't have approved it. So these things change over years.
Yeah, and a lot of things have changed over the years, including if we go back to the early 80s, there weren't quite as many charitable immunity statutes out there, which provided some freedom from lawsuits to the volunteers themselves. But the organizations, although there's some caps on liability across the country, they are in the limelight. They're in the crosshair, if you will, for the monetary judgments and non-monetary judgments.
Yeah, and again, that's why it's important. We're talking about now is who's insured in the policy. So you have to make sure the insured is sued, the insured organization itself is sued, past directors and officers, committee members, volunteers, and we forgot one important, the management company.
Yeah, and the individual managers, if you have an individual manager who's on board. So you want to make sure employees are covered as well.
Mm-hmm. And now we talk, so we say now, okay, so you have to be insured, and you have to be a claim against you. Now, well, before we say what a claim is, you have to be a claim for a wrongful act. Now, it's interesting, the wrongful act wording. If you look at any D&O policy, the wrongful act wording is about, a paragraph or maybe 3 paragraphs long, which I don't understand why you need it, because as they say, any act, So they didn't define what any act is, but they don't have to say anything more than any act. Do you agree?
Oh, absolutely. And, the broader the policy, the better. But also, when a claim arises is also critical in that paragraph, because we've come across policies that there is no claim until there's a lawsuit, and some of them say a lawsuit that has been served. So by then, there's no cost containment. And so having a claim occur when a demand is made, whether it's a written or oral claim, a demand would be the best language that we could find. So when we're reading what a claim is, I want to make sure that it doesn't put into effect something that's way beyond what we want it to be.
And that's important because from our point of view, a claim means a written demand for monetary or non-monetary damages. And that's the probably most important thing in our policy, because you have a lot of situations where there are demands and no actual lawsuits.
Correct. And even if there is a lawsuit, a lot of it is for non-monetary damages. It's for a declaratory judgment, asking a court to declare what a document says. So the money part, if you will, may be an attorney's fee claim, but oftentimes it's just they want the board to do something or not do something, approve an architectural demand, not approve an architectural request. And so the non-monetary portion is absolutely critical to be a covered event.
And it's important too, because you look at most liability policies, they will state that insurance will apply for demand for damages. And in a non-monetary situation, there's no demand for damages. That means there's no claim under their liability policy, which we see a lot of claims under.
Yeah, and there's quite a bit. I mean, I've been working on defending claims for a long time, and it's really not money that most of these are about. It's about somebody got their feelings hurt, or somebody was told they couldn't do something, and heck, it's their house. You shouldn't tell them what to do.
And if your D&O doesn't say demand for monetary and non-monetary damage, you're in trouble.
Absolutely correct. Absolutely correct. So these are all critical components when someone is going to place some coverage and determine whether it's the right carrier to go with.
Perfect. Okay, so let's talk about major coverage concerns. For me, in our policy, historically, major coverage concern for us has always been breach of contract. And the reason why is when D&O was first put together years and years ago, it was really against public policy to provide coverage when somebody in a board enters into a contract, a landscaper or a roofer or a painter, and then all of a sudden they breach the contract. I mean, it's an intentional act. And so why should that be covered? Then historically, we said that, well, we should probably defend the board because the board is the one that makes the they have a fiduciary duty. They have to make decisions. And they have the knowledge and experience. So we did start providing defense for the board. But that, to me, has been a major coverage concern for years.
Absolutely. And this is where another separation occurs between the different policies that are out there, because some absolutely do not cover anything dealing with contracts whatsoever. So the one thing I do want to bring in is I hate using that word fiduciary duty, because you know the different standards of care that apply across the country often do not result in a fiduciary duty, but a duty which is a duty of ordinary care. Either way, the duty would be a breach claim for a termination of a contract. Whether it's right or wrong, we wouldn't know until the end of the day. But most times, the contract issues that come up is not because they breached it intentionally because they just wanted to breach a contract, but they breached it because they thought they were exercising good business judgment because the association wasn't getting the benefit of its bargain. It might not have negotiated its contract for default provisions on the front side, but they feel as though, how much longer can I have this contractor here? They're destroying our place. So I could see why it's something that from a association standpoint, we would definitely want to have covered. And, you know, paying the cost of defense of these policies is a significant amount of potential out of pocket for an association if they don't have the coverage.
And what we've historically have done, and most carriers do it now, is only provide defense, no judgment settlement, right?
Correct. I have not seen any policy that would pay a judgment settlement. However, I have seen some carriers pay some money on settlement only because it was less expensive than the cost to defend the case, and the association was in agreement to let it all occur.
Yeah, and also too, if you start paying judgments and settlements, you kind of make them, more likely to breach the contract. Also, knowing there's no penalty, penalty assessed to it, right?
I don't know. I really don't think so. I take the position that most people are good people. And the reason they're doing it is because of an association related issue. And when I talk about settlements, we're talking about nominal. Association sued for $1 million on a breach of contract suit. And after the first deposition or at a mediation, the contractor sees how bad it is and says, well, we'll just take 10 grand to go away. And so, it becomes a matter of economics. And candidly, associations generally don't want that to occur. They generally want to be found that what they did was right, but sometimes that's a costly venture. And, the carriers on a whole don't usually bring in a hammer clause and let things reach their natural conclusion.
Well, let's talk about that one problem, breach of contract, that we've run into lately. Why don't you bring it up so we can kind of talk about it?
Okay. The issue is governing documents. And governing documents, including restrictions and bylaws and these other documents, really are an agreement between the association and the homeowner of what they will and will not do. So technically, they are contracts between the people. So contracts between them is something that the carriers in the past have issued reservations of rights on, stating that because this is a covenant, a contract, we'll pay your defense costs, but we're not going to pay out your indemnity damages. So this has been an issue that has arisen lately, and some concerns about it lately. And truly, the heart of an association D&O claim almost always deals with a governing document. And that was something that, from an attorney standpoint representing associations, was absolutely critical. And you and I have gone through this for the past few weeks, and fortunately, we've reached a good conclusion.
Yes, it is kind of interesting because the debate was this: if you have a claim for breach of duty claim because the person didn't take care, breached the governing documents, okay, versus breach of contract for breaching the governing documents. In my mind, I kind of separated the two. One's a breach of contract claim and one's a breach of duty claim. However, and you were right, is that they both really are the same claim, correct?
Correct.
So after debating this thing, we went back and forth. We agreed. So at this point in time, I think the people who are listening on this thing right now have to make sure that if there's a claim for breach of contract involving the governing documents, you have to make sure the D&O policy will respond and not treat it as a breach of contract lawsuit, which is very likely to occur. Right now, what we're doing in our travelers is providing the defense. Providing defense, and if there's a settlement judgment available, we're involved in it.
Right. And this is something that you can't get from reading the policy. This is something you got to ask from asking the man himself. And so from the carriers, you're going to want to have a statement of position that a claim for a breach of governing document will not be interpreted as breach of contract under the policy, but more attuned to a breach of duty case. And that will put people in a more comfortable position in making sure that their D&O policy will cover their true needs.
And that's a good point, because again, when we look at it, it's quite clear from the policy, and everybody's policy is pretty much the same, is that if you have a breach of contract claim, it's defense costs only. We don't care if it's governing documents. We don't care if the landscaper. We don't care if the management company. It's all the same. But from your point of view, and it's correct, is that we should separate the two, correct?
And let me ask you this way, Kevin. For the carriers that don't offer anything for breach of contract defense, what are they really doing? Because most claims deal with a breach of duty dealing with the governing documents. And if that's going to be a breach of contract, I guess you have a piece of paper, but you don't really have any insurance.
Well, then those are the same policies that also have that exclusion for non-monetary damages. So most of the D&O policies out there, not most of them, there's a large number of them out there that really will not provide coverage for community associations. And I think that's our point.
Correct, right. So make sure that the top tier companies are giving the opinion that there is coverage.
Okay. All right, so we got here, what's our number one exclusion that you worry about?
There's really a few, but the one that I worry about the most is the bodily injury property damage, as well as the insured versus insured exclusions and how they're modified by policy.
Yeah, I would say right now, the BIPD is the number one reason why a D&O policy is denied. Because what happens is, you talk about the breach of fiduciary duty thing, is that if there's a breach of fiduciary duty because the water is leaking, it comes down 4 or 5 different flights and destroys the paintings on the wall. People believe that because it's a breach of fiduciary duty, it's automatically a D&O claim and should be covered under the D&O policy.
Correct. And we see this all the time from water intrusion. You know, they're doing some resealing of the windows, and during that process, to get a rainstorm and someone's interior gets destroyed. They claim that it was stupidity on the part of the association to do it during hurricane season. And just pretty much uniformly, that would have to go to a different policy, not to the D&O policy, because of the PD exclusion. And so, yeah, we see this on a regular basis, and that's why having enough policies that all fold in with each other and having a good BIPD policy is really important.
Yeah, exactly. Because again, what we see often is that just because they label that word breach of fiduciary duty thing, they send it to the D&O carrier, and sometimes they forget to send it to the GL carrier, and now you have a bigger problem.
Correct. And sometimes one carrier is too slow to respond, and another carrier will pick it up, and then 2 weeks later you'll find out, well, someone else is taking it over. And oftentimes there's different counsel who are in different panels for these companies, so then you have a switch, which is really not good. So making sure that all of the carriers are advised of a policy issue is critical, in my opinion.
I agree. And I guess what you're saying about what scares you the most is that insured versus insured. Is that what you're talking about?
Yeah, because unless that comes back into the policy, if it's an exclusion from the policy, then we have the problem of former board members suing board members, and board members and volunteers getting into it, and the association being sued by other entities like management or by past board members. And unless the insured is endorsed back in, that's another issue that creates a lot of problems.
And it's interesting because you will see a lot of past directors suing current directors, and current directors suing past directors for things they didn't reserve properly or budget properly. And you see those kind of things. And it is a problem because, historically, you're suing yourself, and you should not be able to sue yourself. So insured versus insured exclusion is kind of standard in most insurance D&O policies.
Correct. It is, and it's one of the issues that we always look toward, because those are the nasty lawsuits. It's
Mm-hmm.
usually someone who got removed from the board. They claim they got removed wrongfully, and they start bad mouthing the community and doing things, and then so they sue the association and the association current board members. The current board members want to file a counterclaim, and now we have attorney needs on all sides of these cases.
Mm-hmm.
Yeah. So it's obviously something that we want to make sure is included in the top tier policies.
Yeah, and again, it's one of those exclusions that will come back to haunt people if they don't realize it has to be removed. It's standard in all D&O policies, but you have to remove it.
Right, and then they also need to understand that although it's been removed, it doesn't get removed from everything. There's still that one exclusion that remains in most, if not all, of the policies, and that's the management and association issue. So there's not much you can do about it that I'm aware of, but the insured versus insured is not all taken away. There's always that one little bit left.
Yeah, and certain policies have an insured versus insured. Most of them have a partial insured versus insured exclusion. Rarely have them all. The big issue is that if the insured sues the management company and the management company isn't insured under the D&O policy, most D&O policies won't pick up the management company because the management companies need their own E&O at that point in time.
Correct.
Okay.
And having them named is important, because there's some policies that will not include the management company or the managers unless they're an employee. And that, once again, is kind of a common one. It's not the policies maybe that you come across on a regular basis, but if you look at the whole host of policies that are out there, getting management included is absolutely critical.
Definitely is. So, all right, so what's your number one reason why the claim's denied? What do you see?
You know, what happens is policy shopping.
Okay.
And I don't know who thinks they're the hero for saving $200, but changing carriers is the number one reason for I seeing claims denied, because they changed carriers, they didn't report a claim during the reporting period, and so now a lawsuit comes in, and it's before the new policy took place, didn't have retro dates, didn't have anything in it, and now we have no coverage.
Yeah.
So that's probably the number one thing that I see. I know in other parts of the country, it's reporting issues. So those would probably be the top two from a nationwide perspective. And in my jurisdiction, which is Texas, it would be the out of policy period.
And I would say they both connect. When you talk about reporting, talk about late reporting of a claim, and you're talking about moving things around, because the problem is that a D&O policy is a claims made and reported policy. That means the claim has to be made and reported during the policy period. If you don't do that, if you wait till the policy expires and then report a claim, you have a situation where, or you moved it to another carrier, then the new carrier will either exclude prior acts, may have a retroactive date, maybe have a prior date, maybe you have an application when you sign the application saying you have no knowledge of anything that may give rise to a claim. There's a lot of potential problems and headaches in there by not understanding that the D&O policy is a claims made and reported policy.
Absolutely.
And the only way around that is that if you ever move from one carrier to another, is to, if you have anything that gives rise to a claim, put the current carrier on those before you move it to another carrier.
And I would say don't rely upon the representation of management at that point. Although management may know, the individual board members during that period would know better. And if there's an election which resulted in a large turnover of the board, a prior board member from just a week ago might know about a claim that the new board member has no knowledge of. So it's sometimes
it's tricky. It's
extremely tricky. And that's why I tell once you have a good policy, there's no reason to move unless there's a really, really good reason to move.
And when we talked about late reporting, again, it's the same thing. There's a claim against the board because they improperly towed my car. all of a sudden the manager looks at it and goes, it's not a big deal, and so they throw it away. Now the lawsuit comes in 6 months later, but guess what happened? Now you have late reporting issues that may or may not come into play, but now you also move to another carrier. Now you have a problem.
You're out of luck. And then the management company who took charge of that, potentially they have a problem between their client and themselves. So this is an issue. We need to really keep an eye out for it.
Yeah. So again, the D&O is a claims-made reported policy. If their claim occurs, make sure you report it during the policy period, and you don't have to worry about it. This is one of those claims that's denied that doesn't have to be denied, right?
Absolutely. It's just a little bit of prevention.
All right, this is an interesting one. This is a question I get asked about cyber and D&O. What do you think about that?
I think it's the new thing, but it's something that's coming to fruition extremely quickly. You'd be surprised that some of the smaller and medium-sized companies, from a management perspective, are now having attacks where you wouldn't think they would in the past. But because every association, every management company has personal identification available, which can be matched with a bunch of other data, they're all at risk for a potential claim on the cyber side. And the question we could ask at the same time is, well, why do I need a cyber policy? Because I have a D&O policy. If I did something wrong, it's going to be a breach of a duty. So you're going to defend it anyway.
And that's great because right now, and we don't know how long it's going to be, eventually we will see an exclusion for cyber under a D&O policy. Right now, you don't have to worry about it. There's no D&O exclusion under cyber. So if you have a breach of duty where the person allowed the breach to occur and they're sued, the D&O policy responds. The problem though right now is that when the kind of claim you will see on a cyber is more geared towards extortion. Right now, the number one cyber related claim that we see a lot is extortion related claim and social engineering claim. That's really not D&O driven. It's more about loss of money right off the bat. So if a board of directors all of a sudden turns a computer on and nothing's there but a blank screen and somebody saying I need $20,000 or bitcoins, let it go. That's not something that D&O will come into play. It's more of you need a cyber policy to respond to that.
Would that be the same on the social engineering issue, which looks like a board member sent an email to management asking them to transfer money into a different account?
Now, social engineering is on the crime policy. So if you have a situation like that, again, we see that a lot. It's interesting because we were talking earlier, and I remember I go out of town, and all of a sudden my accountant here gets an email from me saying, please forward gift cards, 10, 20 gift cards, right? And I'm like, I never asked for gift cards, but fortunately she made that phone call and asked me, do I need them or not? So that's social engineering, when they try to trick you into doing something, and it's covered under the crime policy. Not covered under the computer theft or wire transfer or fraud. You need a separate social engineering coverage policy, which again, most people don't have. And I think next month we'll talk more about that. It's a commercial right now. Tune in next month we'll talk about social engineering coverage and other crime coverage that you need to be concerned about.
So Kevin, if we have cyber coverage currently under a D&O policy, why would you need a separate cyber policy?
Okay, so let's say all of a sudden you have a breach of somebody comes in and takes all the data out of your computer. Okay, let's say somebody walks in there right now and takes your server out. Now they have all the data of all your clients. So you have all this information. You have all personal identifiable information. You got bank account numbers. You got names. You got everything, and social security numbers. What happens is that you have to be able to do the notification by law. The state law tells you these things you have to do in the event of a cyber breach. If you don't do that, now you can be held liable. So what happens if you do what you're supposed to do, then there's no lawsuit available. I mean, you can sue, but sue for what? There's no damages because yes, you were attacked. There's a breach there of the information. Now what do? You've done all the right things. You did the notification. You have the call centers. You have all the things you're supposed to do. Guess what? You should be in pretty good shape because at that point in time, you can't, as a lawyer, you can't go to a board and say you should sue, or a unit owners and say you should sue the board because they did their job, correct?
Well, unless there's damage, yeah. So if
Yeah,
the information's
exactly.
already been resold, then you know, and the resale, the reason someone steals something is either for the thrill of it or for the profit of reselling it.
Yeah, but right now what happens is that, yes, if they do that, but when you talk about a cyber loss in a condominium and they steal the data, or they end up, let's say that, you have a file cabinet or you made a mistake. Most of the times you have all that, by law, you have to do something if you believe there's a data breach. Just believing it. Now, it may not happen, or they may be they won't do anything with the data, but by law, you have to do it. And so you do what you have to do. You do the notifications and all those things you have to do. Then all of a sudden is that once it's done, the unit owners can be upset because you allowed it to happen. But what are the damages? Why, can you actually collect damages for something like that?
Right. And every state's going to be a little bit different on it. But
Yes.
yeah, the cost of doing credit monitoring, if you have to do credit monitoring, can also add up. Is that something that would be under D&O or under a separate cyber policy?
Separate cyber policy. Right now, it's $148 per record. That's what it is. So if you have 100 units in a condominium complex, 100 units, and you figure that, well, you have, husband, wife, maybe 2 kids, you could have 4 persons in a unit, you end up spending like $50,000, for a cyber claim. There's nothing to do with the D&O. Now all of a sudden you spend $50,000. Now all of a sudden the board breached their fiduciary duty because they allowed it to happen. Now you have a D&O lawsuit after you already spent $50,000.
And is the lawsuit about failing to buy cyber policy?
It could be. In fact, that'd be a perfect lawsuit right there.
Then we have to look at the exclusions over whether.
Yeah, so failure to maintain insurance exclusion, right?
Well, this is just so much fun.
Okay. All right. Anything left? I think that's it. Okay. Yeah. What's keeping you up at night?
Well, that's an easy one. You guys are keeping me up at night, and because every year or so, someone changes a policy, changes an exclusion, changes an endorsement, and our clients look to us to point them in the right directions. And you guys might enjoy reading insurance policies, but I could tell you, attorneys, if they have to read 5 or 10 insurance policies, you're going to really have to pay them well.
Yeah.
And it's the only way, because no one offers a true comparison. We all have a checklist of what we want to have in a policy and what we don't want to have in a policy. And so that's probably one of the things that bothers us the most. And then because there are so many policies out there, once again, that shopping for policies really creates a problem, because oftentimes the client doesn't call you and say, hey, we're thinking about going from A to B, what do you think? They usually call us after a claims come in and they've switched to B and we have to give them bad news.
Yeah. And you know what? I think you nailed it. In terms of us keeping us up at night, is the same thing. These policies are like $1,000 policies. And when you have a claim, you're talking about $30,000, $40,000 a claim. So you have to write a lot of these policies in order to make money. And the problem is, in my 30 years of doing condo D&O, you never make enough money to catch up. You always end up trying to keep growing, but it never, because the claims are becoming more and more unique every time you take a look at it. And so what happens is that you have to look at the D&O policy and say, should this be covered, shouldn't be covered. And the perfect example is the breach of contract. Historically, if you say breach of contract, it means breach of contract. Now, it's breach of contract, but maybe here it's not breach of contract. So we just expect coverage in the D&O policy.
Right. And then what's next? There are a lot of really clever plaintiffs attorneys around the country. And I come across one every once in a while and I go, well, what you've sued for is not something you can file a lawsuit for. And they go, well, we'll see about that. People are always making new law. So that's the next thing, is to seeing what creativity will result in a new claim, and then how will the policy be interpreted as to that issue.
Yep, that keeps up at night. So, okay, I think that's it for us. Do we got any questions? Sherry around?
Yes, I'm coming back, Kevin. Yes, as a matter of fact, we do have a couple of really good questions that have come in. I have a question here from Debbie, and I'm not sure I'm pronouncing your name correctly, Debbie, but it's Kershke from Crest Management in Houston, Mark. in Houston, Texas. So our state, go Texas. Okay, Debbie says that she has a new board member who constantly goes to the common areas, making what he feels is needed repairs. And he ended up getting hurt, and he climbs the ladder, etc. Debbie advised him not to do that. And again, he told her just a few days ago that he was going to go out there and do some more work on the swing set. And she said, no, please call our contractor to do it. So Debbie's on the board. She also works at the management company, and she wants to know, what should they do about this? How should they handle this?
Well, this is a board member who's acting outside their course and scope as a board member. They're acting as an employee without pay, so a volunteer doing work that they shouldn't be doing. I think that the volunteers should pick weeds, but they shouldn't operate chainsaws or go up on ladders. And if they're going to do something which is really potentially bringing some financial harm to the association, they should do whatever is necessary to make him not be a board member any longer. I do have some clients who have gone to the other extreme and said, if you want to volunteer and do things that we don't want you to do, first of all, we're telling you you're not to do them. And here's a release form that you should sign, to where when you fall off the ladder, you understand that we've told you not to do this. And if you get hurt, it's your own problem, regardless of whether you used a ladder that was in bad shape, which could have been negligent to even have. So and then if they go, well, I'm not going to sign that, I'm going to do it anyway, candidly, they become a trespasser.
Let me add one more thing to it too, Mark. And I think when there's a D&O claim, we check the capacity. You may label yourself as a board member, but you're not acting capacity of a board member. You're acting capacity as an irritant next door neighbor or something else. So if you're not acting your capacity, the D&O won't respond.
Right, but the association funds, unfortunately, oftentimes are exposed. This is one of those situations where, even if you had a workers' comp policy, if it doesn't cover people who work without compensation, and there's some minimal insurance available for a volunteer injury policy, but it's minimal coverage that's available, you're really putting the association funds at risk. And as a board member, he needs to put his board member hat on and put in there that I am breaching my duty. Now, I don't know which law firm represents them, but the board as a whole could get a legal opinion which would state that this is something that they should not be doing. And then if they continue to do it, that person may have individual culpability as opposed to tying it to the organization at all. And what Kevin said is absolutely right. We have lawsuits against directors, which are not directors and officers lawsuits.
Mm-hmm. Okay, great. Thank you very much. Thank you for that great answer. And I have another one that's come in. Walter Fryer would like to know, I will assume that each of the D&O products Kevin Davis Insurance offers does provide coverages you have noted as being essential. You mentioned essential coverages before. Should we assume that should one or more of these provisions not be included, that if they would be highlighted?
Yeah, okay. I think yes, the answer to your question is the things that we're talking about are the things that we have under our policy. And things that we learned, like we just learned about the breach of contract, we try to fix it to make sure that you have the broadest policy out there. And that's our goal, to make sure that we constantly have conversation with people like lawyers, attorneys like Mark, that says, hey, wait a minute, I think there's a problem in your policy. We go back and say, okay, let's decide, should we fix it or not? Or do we say that this should not be covered? And that's what we do in terms of being involved in the industry. So the answer is yes, we do have the coverages we talked about.
Mm-hmm. Okay, great. Thank you. Mm-hmm. Christina Keel has a question. She says, do you see plaintiff legal fees included now on most D&O, and GL policies, and does this occur often?
Well, on the GL policy, when it's a claim for bodily injury, the attorney's fees are a critical portion of it. And if they're not covered, that's problematic. So most of the policies that we see will cover the damages for a covered occurrence, but there are exclusions. It may be as simple as intentional acts on the part of the board members, but they are out there, and most of those do get covered.
Mm-hmm. Okay, great, thank you. Mm-hmm. Another question from James Gibson. Thank you, James. What are your thoughts on wrongful foreclosure claims? Will carriers ever include this coverage, or is it lost in the abyss in our industry?
Well, you can go ahead. Ask, you go first, and then I will talk. I will go after that. Go ahead.
Well, I personally have defended wrongful
Yeah.
foreclosure claims since 1983.
Mhm.
And there's not as many as there used to be because people are getting smarter about how to do a foreclosure properly. And most states have come up with what we call a right of redemption, to where if a foreclosure does occur, there's a way of unwinding it within a certain period of time after the sale. But I've never seen a wrongful foreclosure claim not covered by a quality D&O product.
Okay, now I guess what this agent or person is talking about is that we have a state in Nevada where they overbilled several years ago, and also you had a glut of wrongful foreclosure. So most D&O carriers stopped providing that coverage in Nevada.
Wow.
Yeah. And now we're at a point where some people have higher deductibles on it. Right now, what we're doing is coming back and providing wrongful foreclosure coverage in Nevada.
And I guess the question is, if a foreclosure was wrongful, why was it wrongful?
Yeah.
Is it because the attorney did something wrong or the management company did something wrong? Generally, the board members don't get involved in the process other than to say these people owe assessments. They should, under our collection policy, be foreclosed. So
Yeah.
there's possibly an E&O on both professional sides that may cover what the E&O doesn't cover.
Well, you got a situation like in Hawaii, we have judicial foreclosure versus non-judicial foreclosure. Some you're allowed, some you're not allowed. And I think it was a problem in Hawaii under the same thing. You were doing non-judicial foreclosure, and you weren't allowed to. So you had a class action suit over a bunch of associations. They were just doing it incorrectly. So there's certain parts of the country where, again, as underwriters, what we do is say this is a losing proposition. So here we have to either put a higher deductible on it or exclude it for a short period of time and then come back in and say it's okay now. That's a good question. That's a good question.
Yeah, very good question. Right. And I have another one from Lisa. Lisa would like to know, our client is doing renovations and a unit owner is upset they're taking so long and hurricane season is coming soon. The D&O denied for the construction exclusion. The D&O, I'm not sure what she's saying. Denied for the construction. Yes. Mm-hmm. And then she asked, is that valid?
Mm-hmm. Yes. And again, we talked about before, we talked about property damage. When a property damage loss occurs, when you sue for breach of fiduciary duty because they did not handle the property properly, it's a property damage and it's excluded under the D&O. What do you think about the GL, Mark?
You know, that's one of those situations where you might fall into a gap of coverage.
Yeah.
Because if the damage occurred not as a result of a normal occurrence, but as a result of a failure to exercise duty on the part of the board, I could see the GL carrier pointing at you and you pointing at them and everyone holding their hands empty.
Yep.
So the way to deal with something like this is if it's the association that's trying to get this owner to move the property along, the association has the right to file a lawsuit because they didn't complete timely. The owner could then file a counterclaim against the association saying, well, I have not completed timely because you've limited my hours in the elevator. So there's no property damage. It's just the project's not completed in time that resulted in damages. And then I think the D&O might say, yay, we're going to get involved on that defense of the counterclaim.
Mm-hmm. That's something you got to look at. It's interesting. That'd be an interesting kind of claim. So,
right. That's why I said look at, not defend.
Exactly. Yes. Okay. Any more questions there, Sherry?
No, I think that's the last one, Kevin.
All right. Good. All right.
Great. Thank you, Kevin and Mark. Thank you so much. And I'd like to tell everybody that, again, that I record all of these webinars and put them on our website, which is kdisonline.com. You can listen to today's webinar and all of our past webinars by going on our website. And please join myself and Robert Flowers, Vice President of Travelers Insurance, for next month's webinar, which is why associations need a crime policy. Thanks so much, guys, and have a great afternoon.
Thanks a lot.
Thank you.
Take care.